Good morning, good afternoon, good evening, everyone. So my name is Ahmad Saleh. I'm a partner and head of patents and designs, R&D and innovation at El Tamimia and Company law firm. I'm also the IP partner in charge of our IP department in the Kingdom of Saudi Arabia. Since the adoption of Vision 2030 by His Highness, the Crown Prince Mohammed bin Salman in 2016, the Kingdom of Saudi Arabia has been actively working towards driving important economic changes inside the country and in the region. One of the key strategic aims of Saudi Arabia's Vision 2030 is to diversify its economy from oil-dependent economy to a knowledge-based economy. Concurrently with the annual World Intellectual Property Day on 26 April 2018, His Excellency, the Minister of Commerce and Investment, Chairman of the Board of Directors of the Saudi Intellectual Property Authority, Dr. Majid bin Abdullah Al-Kasabi, launched the strategy of the Saudi Intellectual Property Authority, SIPE. As part of the key objectives highlighted are raising awareness of the importance of intellectual property and the protection of its rights, advocating the role of intellectual property in the building of an advanced economy based on knowledge, and the establishment of information bases and exchanging information with local, regional, and international authorities in the field of intellectual property. A key structural change was the consolidation of all IP-related functions and divisions under the umbrella of SIPE, including the Patent Office and the Trademark Office, responsible of registrations of patents and trademarks, respectively, in KSA. Since then, SIPE executed strategic cooperative partnerships with international offices, including the USPTO and the Korean Intellectual Property Office, for the purpose of exchanging information, instituting global equality measures, and streamlining IP registration procedures in order to attract global industries to the Kingdom. The broad mandate of the Kingdom, aiming to improve intellectual property infrastructures, extends to beyond IP registrations, including IP policies, enforcement, and core systems. Many of these objectives are also under SIPE's umbrella. This seminar is one of a series of seminars we'll be conducting with SIPE in order to shed the light of the key changes affecting the KSA IP and innovation ecosystem foreseen by SIPE. In these future seminars, we'll be discussing SIPE aim in terms of adopting new policies, international collaborations, and enforcement bodies, and so on. In today's seminar, we will be focusing on the topic of IP registrations. For this, we are happy and delighted to speak and to have with us Mr. Abdulrahman Al-Uyuni, Executive Director and Head of the Trademark Functions at SIPE, and Mr. Majid Al-Ghamadi, who is a patent examiner with a Master of Biotechnology and 15 years of experience in patent examination. Mr. Abdulrahman, the question everyone asks today, and today we've seen the formation of SIPE, and everyone, including brand owners and patent owners, what is the impact of the establishment of SIPE on these IP right holders? Is it only an administrative restructuring, or are there any substantive changes brought by the formation of SIPE?
Thank you, Mr. Ahmed. Thank you, everyone. We are glad to be part of this panel and hope the attendees to get a useful information and be aware about. Regarding your question, to be honest, Saudi Arabia, part of its 2030 vision is to improve all aspects of the trades. Part of that is the IP aspects. So previously, if you know that trademarks was under the Ministry of Commerce control, and also the copyright was under the Minister of Media. Also, the patents and industrial designs was under control of CAT. So the decision was made to collect all these aspects to be under one authority to re-regulate all the aspects, to be in the international standards, to meet also the obligations of the kingdom with the current conventions. So also to strong the enforcement of the rights of all these IP fields. We start with the copyright enforcement. We had a number of campaigns we've done last year and also the beginning of this year. The enforcement of copyrights was really in Paris. Most of the shareholders of the IP aspects. Also, we are in transition period to move the enforcement of trademark infringement to be controlled under SIPE, hopefully soon. And the patent, as you know, it is part of the court actions. So usually the owners of the patents usually reach the court to get any orders in relation to the infringement.
Thank you very much, Mr. Abdulrahman. Today, the KSA is seeking to attract more and more investors in Saudi Arabia in various industries, including entertainment, esports, and other. And as you know, trademark registration is really a key aspect for protecting business goodwill. So how do you see this? Do you see there is an increase of number of trademark applications in KSA, let's say before and post-COVID? How do you see the situation today in terms of trademark registrations, which might be an indication in terms of investments and doing business in Saudi Arabia?
Great question. To be honest, maybe this pandemic that happened, COVID-19, it was a very good test to show how was Saudi Arabia is ready to such incident. When we talk about trademark registration here, we can find that the number of the registrations or the application being submitted to register trademarks, it's almost the same, even it's increased, because Saudi Arabia was fully prepared for such circumstances. In fact, we've been using the technology here to make all the process of the application only online. No one need to reach site physically to submit his application. Everything's done online. Always we treat the applications equally. We do the full process electronically. Even the communication with the clients or the applicants. Also, we've been treated as normal. All works was
conducted. Yes, absolutely. And actually, we do agree with that, and our team in Saudi Arabia registering trademarks actually didn't have any difficulties working with your online system, which continued to support trademark registration throughout the entire pandemic. But from the volume perspective, have you seen, not from the administrative perspective, have you seen any or felt any slowdown of the volume of trademark registrations in Saudi Arabia caused by the pandemic, kind of a slowdown in the investment, on the investment side in Saudi Arabia?
Okay. In fact, Saudi Arabia or side, they decide to be very cooperative with the stakeholders, which are the applicants. When we asked them, or to be honest, we announced that people can submit their application even without the power of attorneys from their clients. So we accept just a normal paper that we submitted, and we give like a permission period until they can submit their application. So that's the reason that helped our clients or our applicants to submit their applications even on time, on the time that they plan to submit. As you know, as you're a lawyer and a senior lawyer, know that some companies, they decide to register their trademark in the same time and around the world at the same time. So usually they submit it in specific time. So at that time, Saudi Arabia was ready to receive any application. We give exceptions in relation to power of attorneys. We give exception even for permission for priority files. Also, I will leave this side in relation to patent. I believe Mr. Majid will cover that. But already patent, they have get a lot of permissions. They extend the time, they extend the deadlines. So the volume, it was almost the same. Nothing that much dropped, except of course some countries from Europe. They already shut down everything, so they couldn't submit their applications or provide their lawyers in Saudi to submit their application. However, everything was normal. Even though, we received more applications, especially after when the lockdown, it's more, when the lives get back to normal, we received more of the
amount of the number of applications filed. And knowing that the pendency period of a trademark registration is very important. The time between filing and registration of a trademark is extremely important for the enforcement measures in Saudi Arabia. What is the current time frame for the registration of a trademark in Saudi Arabia, and do you foresee any expedition of this process in the future?
Okay, to be honest, when we come to this question, a lot of people, they say, okay, when the trademark was under control by Minister of Commerce, that the application being treated in just 7 working days. Really, I appreciate what Minister of Commerce have done for the trademarks. However, as SAIB looking forward to improve the quality of examining the trademarks, and also to improve the way that the examiners examine the trademarks, to give the rights to the right trademark to be registered and be protected. So, and at that time, by law, it is the registration of the trademark usually take 90 days. This is what the law said, and as you know, 90 days. This is the minimum, the maximum that the trademark department should give the final decision in relation to such application. However, in fact, currently we just spend about 14 working days to give the final decision if we accept this application or inside this 14 working days. There's a formal examination. There's a communication with the applicant. There's a substantive examination. Also, there's a committee to give a final decision. I don't say a committee as official committee. It is internal committee in the department between the examiners to give the final decision in relation to an application. All these steps, it's considered the quality. we want to raise the quality as much as we can, because we believe there's some trademarks that have been submitted, not really should be protected, so we have to reject it. And there's a really trademark should be accepted, and that's why we put this circle, the application to be in this circle, and get the final decision 14 days. As we said, there's some exceptions. There's some files need to more than 14 working days, because there's some documents that we ask the applicant to submit. So in general, it should be maximum 14 working days until the decision be made. Then, as you know, there is a publication period about 60 days after the acceptance. During this time, should be and if there's any third party would like to exit this application.
Should the applicant expect a reduction or an increase of official fees in the future?
It's a great question. I believe everyone talking about money these days. So, however, most of people, or we can say the authorities, they are looking for a lot of money. Inside, we are at this time we are studying to decrease the fees of these applications. Final decision wasn't made yet, but hopefully soon we will hear the good news about the fees of application, register of applications.
Good news for who? For SAP or for the applicants?
Of course, it's for the stakeholders, for the applicants.
Okay.
Should be decreased, inshallah. Hopefully we'll hear something soon.
Very good.
But I cannot give any numbers.
Thank you, Mr. Abdulrahman. Mr. Majid, it's a great to have you here. My question for you relates to patents, and nowadays with the advancement of technology and innovation and the speed of the pace of innovation, patent owners are looking for more speedy patent registrations, and this is as technology is nowadays becoming obsolete extremely quickly. So what is typed intentions to expedite the process of patent prosecution, and how can patent applicants expect some special programs for expediting the prosecution of patent applications in certain industries, for example, which are of importance to the kingdom, such as, let's say, agriculture or artificial intelligence or blockchain?
Thank you very much for having me today. Actually, the problem of pendency long period is a global problematic. This is a critical issue for the most patent offices. With SAIB, we will address this issue by creating several new projects. We plan to increase the number of examiners so that we have sufficient examiners in order to raise the quality and quantity of our examinations to reach the global standard. Also, we plan to build a high-quality examination system to improve our capabilities and increase our professionalism. This new system will improve our examination productivity, increases efficiency, and reduce the backlog and pendency period. The project will involve, for example, the creation of an IT infrastructure that will include the use of artificial intelligence search system to maximize examiners' expertise, especially complex technology training. We also looking for introducing improved examination process through telework program and flexible hours for examiners to help them to raise the the quantity of
patent applications. It's great to see all of this, that Dr. Majid, all of these additional capabilities which are being introduced by SIPE in terms of examiner numbers and the quality of examination. How is this affecting the pendency of a patent application? What is the current for the audience information, what is the current average pendency period for a patent application between filing and the grant, and how do you expect this to change in the future?
Yeah, actually, the pendency times period it ranges between 3 to sometimes 5 years, depending on the technology field and the other criteria. For most patent offices, there is a relation between the quantity of patent application and the quantity of patent examiners. Okay, also the mechanism of dealing with the patent examination. So until now, we have just up to 50 examiners. So
okay.
We are looking for writing this number.
Increase the number
up to 100 examiners in the next 2 years. So also we adopt special programs and like a BBH program, fast track, with certain offices like USPTO and KIBO, also JBO, that can increase
expedite the process of examination.
Yes, yeah.
Excellent.
So, this is can make the period shorter than
shorter. Besides the USPTO and KIPO, the South Korean Intellectual Property Office, are there other patent offices with which you foresee concluding patent prosecution highway agreements?
Still, until now, there is no other than these 3 offices. But maybe in the future, of course, we'll looking for more the collaborative between other offices.
Very good, excellent. Thank you very much, Dr. Majid. Returning to Dr. Abdulrahman. Dr. Abdulrahman, you're responsible of the trademarks section at SIPE, and you're also responsible of the industrial designs as well. So my question to you relates to industrial designs here. And also the intersection or the overlapping with 3D trademarks. And first of all, we would like to understand what's the SIPE position with respect to the registration of unconventional trademarks like 3D trademarks. And then we would like to know your position with respect to the simultaneous and concurrent registration of a 3D trademark and industrial design. Is this something which is admissible and acceptable under the KSA practice? And how would SIPE deal with a simultaneous registration of a single and the same article under both the 3D trademarks and the industrial designs?
Yeah, I think the question that you asked, Mr. Ahmed, it's a really smart question, because a lot of companies, they would like to protect as you know, a trademark usually you can renew the protection period. So however, if they register as industrial design, sometimes it's only just 10 years in Saudi. In fact, if the 3D shape provides a function, then it will not be protected as a trademark. It could be an industrial design. However, not a trademark. So I think the main issue is if this design or this 3D, three-dimension design could provide a function, then definitely I would reject it as a trademark. However, also in industrial design, if you submit the same that rejected the trademark, 3D trademark, if it is not really a new and there's a non-novelty about it, about this the three dimension, also it could be rejected. Even it is just a formal examination that in industrial design, but still if just a design that a normal design with the 3 dimensions, then could be rejected. But as long as it is just a formal examination, then it could be accepted as an industrial design.
Okay, so is SIPE conducting substantive examination with respect to determining if there is a functional aspect or there isn't a functional aspect, or this is left to the courts?
We do deep examination. That's why when I mentioned at the beginning, now it takes quite a long time to study the application of trademark. So usually we study it very carefully, make sure it is it's a right application, it's a right logo that could be registered, or 3D could be registered. So that's why we usually communicate with the applicant sometimes, asking for explanation sometimes to reach the right decision in relation to such application.
Dr. Abdul Rahman, today with respect to trademark enforcement, this is...
Mr. Ahmed, I'm not a doctor, please. I'm just Abdul Rahman.
Mr. Abdul Rahman, thank you for modesty, first of all. With respect to the enforcement of industrial designs, now we know that in Saudi Arabia, the enforcement of trademarks is something which is widely common today, and you have established authorities and divisions to take care of that. From the administrative perspective, I'm speaking. Now, with respect to industrial designs, it's a bit less common. However, we started to see an increase of number of, popularity of industrial design registrations. How is SIPE planning to cope with this from the enforcement perspective? Are you planning to put some measures in place from the practical administrative perspective for applicants to be able to administratively enforce their industrial designs?
As you might know, by law, if the owner of the industrial design find an infringement in relation to his or her industrial design, by law they should reach the commercial court, which is a competent court, to issue an order to stop the infringing activities. Previously, it was a committee inside, and before that it was in tax. But now it is the competent court, it is the commercial court that can, the owner of industrial design can seek any orders or compensations in relation to the infringement of the industrial design.
Okay, thank you very much. So if I understand well, there are no administrative procedures for enforcing an industrial design now, and the applicants have to go in front of the courts for that.
Exactly.
I would like to get a bit of practical flavor here. So I'm turning towards my IP team in Saudi Arabia, and I'm happy to introduce my colleagues, Bashir Abu Shara, who is a senior associate at Al-Tamimi and Company, and Salih Al-Habshi, who is an associate from our office in Jeddah, Saudi Arabia. So starting with Salih. Salih, from the practical perspective, speaking about enforcement, we know you're located in Jeddah, and Jeddah port is the largest port in Saudi Arabia, and this is one of the main entries where counterfeit products enter the Saudi market. So what are the measures which need to be taken by brand owners in order to control entrance of counterfeit products through the Jeddah ports and other ports? And of course, the obvious question which follows is it a consolidated one measure which is taken to control the entry of these counterfeiting products through all the ports, or one should go really individually to each and every one of these port authorities separately?
Okay, thank you, Mr. Ahmed. Basically, in Jeddah, we have two main ports, Jeddah Islamic Port and Jeddah International Port. And as we all know that KSA is considered one of the countries that import different types of product. And most of these products are usually are entered through the Islamic Jeddah Port. We can also mention that there is ports in eastern region and the western and everywhere in the KSA in order to avoid any illegal entrance to these ports. The measures that I will recommend, or actually I highly recommend for the investor and business owners, brand owners and trademark owners, in protecting their trademark from infringement or counterfeit, is by having a custom recorder. Basically, the custom recorder is something that needs to be registered through the customs authority. In order to have a certificate or a registration, you will need to have a trademark registration in the country of origin in KSA inside. Once you have the custom authority approval, you will have a circulation that has been made by the custom authority to all the ports in informing the ports that this trademark is owned by the brand owner, and the brand any suspicious or suspected products that needs to be referred to the agent that is registered in the custom authority. And we are considered as one of the agents that we have signed a memorandum of understanding with the custom authority. So we can have this type of service that we can provide. I also need to mention that in the Jeddah International Port, most of the products is luxury and high value products that enter through this port. And during the COVID-19, the customs authority has taken certain measures to certain products that are related to consumer protection, which we have visualized that most of the products during COVID-19 was masks and sanitizers that are considered counterfeit and infringed products. And also, I recommend for the businessmen and investors and also entrepreneurs to have a training session year to year. By having this training session, it will increase the awareness for the custom officials in order to spot the suspected product easily, and also to facilitate them to find out which is genuine and which is counterfeit. Again, I do highly recommend for business and investors and brand owners to have a custom recorder and also a training session for the custom officials.
Thank you, Saleh. And if this custom recordation is applicable and effective throughout all the ports of Saudi Arabia, or it has to be done separately?
Basically, the custom authority is centralized in KSA. So by submitting the application, it needs to be in Riyadh, which is located the custom authority. However, the attendance and spotting these products need to be physically attended to the port itself. However, we also forgot to mention that there is also one port that is far from Jeddah, 100 kilometers. It's King Abdullah port, Rabiq port, you can also mention. This port is most likely considered for pharma and industrial products. Most of these companies are located there, so they have certain procedure that needs to be taken through these products. And we are currently working on having certain arrangement with the customs authority in this perspective.
Saleh, you've mentioned the trademark registration in Saudi Arabia as a requirement to custom recordation.
Yep.
What about famous trademarks? Many international companies today enter the Saudi market based on their international fame without prior registration of their trademark. How do the KSA authorities deal with famous trademarks?
Famous trademarks based on the GCC trademark law, Article 3, Clause 14, have stated clearly that any famous trademark cannot be registered or copied or translated. And how can we predict that the trademark is famous? By three measures. The first measure, we can say that if the trademark has several registration in different countries. For instance, let's say in KSA we have a trademark registration, and we also have in Egypt, Kuwait, and etc. This we can say that this is a famous, and also if the trademark is well known in other country than the country that is registered in. For instance, let's say if the trademark is well known in KSA and it's well known also and has a high reputation in US, this also is considered as a famous trademark. And the second measure, we can say that if the trademark was registered before 30 years ago, the date of the trademark registration. The third point is the price of the trademark in the market share, which is evaluated by the competent authorities or the authorized agent by the competent authorities. By these three measures, we can consider that the trademark is famous.
Okay, and are the administrative authorities in Saudi Arabia willing to enforce such a famous trademark without registration?
As I have mentioned, in the trademark, in the GCC trademark law has stated clearly that the trademark, the famous trademark, cannot be registered. However, the law kept silent in enforcing the famous trademark. So we can handle this famous trademark by enforcing it through the court, and they will take the necessary measures in dealing with this. And also we can state that it's unfair competition. We can take it also to the competition committee and filing that by the two merits, which is unfair competition and also the confusion for the consumer.
Thank you, Saleh. Returning to Mr. Abdul Rahman. Mr. Abdul Rahman, what is the side practice with respect to the opposition of a trademark by the owner of a famous trademark? Is this something which you would accept as a request for a brand owner having a famous trademark opposing the registration of another entity trying to register the same trademark in Saudi Arabia?
Okay, if I understand your question well, you're asking how we treat an opposition by a famous trademark owner in relation to an application being submitted to SAI. This is the right question, right?
With respect to an application being submitted to SIPE by another applicant trying to register the same trademark.
Perfect. I will assume here the application being accepted and being published. Any third party, including the owner of the famous trademark, definitely they have the right to file an opposition within the publication period, which is 60 days. As you might know, in some cases, on some application situations, the owner of the famous trademark, they always, because this is in my experience, most of the companies, they thought always their trademark is very famous, and they think the others, they're trying to mimic or copying their trademark or doing some very similar trademark like the one that's famous. So sometimes the site or the department, they reconsidering the situation and also check all the documents being submitted during the opposition. If the opposed company, they have the right and they prove that it is similar to their trademark, then of course the application will be the application of the trademark that we submitted will be refused, and then the trademark, the famous trademark, will won this issue. However, still the other party that's been refused, they have the right to go to the court to prove his position and might won the case against this company. So usually the final decision here should be by the court.
Okay, so do you recommend that brand owners with famous trademarks do proceed to the registration of their famous trademarks in Saudi Arabia?
It is not required to register a famous trademark by law. However, of course, 100%, I do advise any business owner, even famous or not famous, please register your trademark in Saudi, especially in the field that you are usually using it. For example, some famous, I don't want to say names, but some famous trademarks, they register in 45 classes. So they already submitted 45 applications to protect their trademarks. Even it is really very famous. As I mentioned, I cannot say names, but there's examples for famous companies, famous trademark, they register in all 45 classes. I'm sure about the 42 and the old classification is classification, but I'm sure they already submitted the new application for the other classes.
Thank you, Mr. Abdulrahman. Going to Bashir. Bashir, we cannot speak about attracting investments and foreign businesses in Saudi Arabia without speaking about the legal vehicles for entering into commercial partnerships and doing business in Saudi Arabia. So I would appreciate if you can shed the light on the main legal commercial vehicles available to business owners and investors who want to do business in Saudi Arabia, and what are the main use of these vehicles and any challenges, if any?
Absolutely. Okay, thank you, Ahmed, and thank you all for attending and allowing me the opportunity to speak at this webinar. So when entering the Saudi market, investors who own IP rights will need to consider what sort of arrangements would best suit their needs according to their type of project. Setting the right vehicle is very important according to the type of project business, venture, enterprise that the IP owners are looking to invest in. And so in this respect, one primary business need that sometimes is overlooked, and surprisingly is, despite its importance, is the need to protect the IP rights in terms of prior registration, but also in terms of the agreement, so contractually. And the most common forms of contracts agreements which would typically come into play in this context are, and those are the legal vehicles that Ahmed, you referred to in your question, those are commercial agencies, distribution agreements, franchise agreements, joint ventures, especially when we're talking about the transfer of technology and know-how, and last but not least, IP licenses, especially when we're looking at the brand usage on signages and so on. So I'll briefly speak about each of those agreements next, but suffice it to say for now is that the common feature between those agreements is that they all license IP in one shape or form or another. Another common feature between all those agreements is that one actual challenge has to do with the issue of enforcing governing law and jurisdiction clauses. Governing law and dispute resolution are also extremely important to consider in that context, and including clear, robust, detailed provisions because of that, which protect the IP rights, govern the scope of usage, and set limitations in such agreements is key. So I'm not going to delve further into the details because this will require an entire webinar on its own, but appointing the right legal counsel with absolute knowledge of the Saudi legal framework and how to deal with the Saudi courts and litigation to guide and advise on such considerations when it comes to IP provisions, contractual protection, governing law and dispute resolution clauses is very much equally important. So to start off with agencies and distribution agreements, now while the one law governs both, and that is the Saudi Commercial Agency Law and its implementing regulations, which governs both, as I said. It does not explicitly distinguish between agencies and distribution agreements, but as most people will know, agencies do differ from distributions. Unlike distributions, an agency is more limited in scope, and therefore the IP usage and will not allow an agent, for instance, to import, store products carrying IP rights. It may allow agents to market, at best promote, maybe even sell those products, but those sales would mostly be concluded in the name of, or at least in favor of, the principal IP owner. A distribution agreement, by contrast, is more encompassing in terms of the aforementioned activities, but it also entails both wholesale and retail activities, storage, of course, import, customs clearance of products where the distributor is actually physically distributing products, distribution, promotion, advertising, and so on and so forth. And it is a must to have in certain fields, such as the pharmaceutical and medical industries. In those industries, for instance, foreign principals, who are the pharmaceutical suppliers, the medical manufacturers, and the IP owners, will have to appoint local distributors who will need to register with the Saudi regulators. And for instance, in the Saudi, in the pharmaceutical and medical industry, by that I mean the Saudi Food and Drug Authority. Such registrations will carry with them the understanding that the distributors are obviously authorized to use the IP rights of the foreign entities in order to be able to import and distribute the products which carry those IP rights. For instance, like I'll just go back to that one example, but of course other examples exist in other industries and fields. So for instance, with respect to medication, the drug itself will carry a number of IP rights, be it patents, be it trade secrets, the branding, the labeling, the trade dress, so on and so forth, the copyright. So the distribution agreement in that respect will include, must include robust IP licensing provisions which protect the IP owner. And this takes me next to the issue, which is a challenge, which relates to registration and deregistration of agencies and distributions with the Ministry of Commerce, the Saudi Ministry of Commerce. So under the Saudi Commercial Agency and Distribution Law, registration is a requirement. It is a legal requirement for agents and distributors to be able legally to conduct their activities in respect of the products and IP rights. Yeah. Now, the default position with the Ministry of Commerce in this respect, when it comes to registration, is that it treats all registered agencies and distributions as non-exclusive. So that means, basically, practically speaking, is that principal IP owner can appoint other agents and distributors to sell the same products. Unless the agent and distributor, of course, disputes this non-exclusivity and claims exclusivity, that would be the default position. And if they do dispute it, then they can escalate the matter to the courts, and then the courts would have their their final word on the issue. However, the main challenge arises from really the having to deregister an agreement with the Ministry of Commerce when the foreign principal or IP owner wants to terminate their agreement with that particular agent or distributor. So in this respect, effective termination in a Saudi context can only occur upon deregistration. And so without that deregistration, an agent or distributor can continue to freely exploit the IP rights in the KSA, notwithstanding the fact that they will have received the notice of termination. So to deregister an agreement and prevent that sort of further unauthorized use of their IP rights post-termination, IP owners, principals may have to resort to the courts, and that could entail prolonged proceedings. And that takes me back to my very first point, which is having proper Saudi legal counsel at the very early stages of entering into these sort of agreements is key to guide and advise on the contractual provisions to include and the issues to consider. With respect to franchise agreements, as many of you may have heard or already know, the Saudi authorities passed a new franchise law that came into effect early April 2020. However, its draft implementing regulations have yet to come into effect, but we anticipate this will happen in the very soon future, maybe coming weeks or next month. Both the law and regulations include detailed provisions about the licensing of IP rights and cater for different forms of IP in this respect. So that could, the full spectrum, really, know-how, trade secrets, branding, trademark, trade name rights, copyright, neighboring rights, patents, designs. And in that respect, where like sort of you think of a franchise requires or entails the use of inventions. A new development in the law and its regulations is the mandatory requirement of having to submit to franchisees and register with the Ministry of Commerce a franchise disclosure document before signing the franchise deal. So the implementing regulations detail the procedures to follow and the content to include in that franchise disclosure document. The required content and details are quite vast, really, with the aim of allowing the franchisees to make informed decisions about entering into the franchise. The information required in the disclosure document includes history, background of the franchise business, years of experience and presence in other foreign markets, financial data and information on the business, the franchise, you know, how it's doing in other markets and its country of origin, where the franchisor or principal reside, the existence of any claims, lawsuits against the franchisor, et cetera, But more importantly, the regulations also have an entire section including the IP rights in the disclosure document, and that pertains to information that must cover nearly all aspects of the IP, whether it's registered in the KSA or not, and if so, if not, why, whether it is the subject of any proceedings in any jurisdictions, and how the IP was developed, and how it's being commercialized elsewhere, and how profitable it is. So like agencies and distributions, one main challenge that we anticipate may arise is to do with deregistration upon termination of the franchise. And we look forward to seeing how the Saudi authorities deal with this in light of the new law.
Absolutely. So this brings the obvious question to Mr. Abdulrahman. Yani how, what is the, what SAIP's policy with respect to the deregistration of the light on this very important aspect, which has amplifications on, as Bashir highlighted, on different laws and commercial legal vehicles.
Okay, thank you, Mr. Bashir. It was really great information.
Most welcome.
In relation to the trademark license, usually the trademark license agreement duration must not surpass the protection period of the trademark.
That's correct.
And adding to that, the parties may mutually end the license agreement. And if that's happened in the mutual agreement, currently we are improving online service to do to cancel the registration of the TM license, especially if both parties there agreed to end the relationship. However, if there's any dispute issues and the TM license is still valid, side cannot do, the side cannot take any steps in this situation. The party, the party who's has the interest to go to stop this license have to go to the court.
The courts, yeah.
To order to stop it.
Yeah.
So in the mutual agreement, you can do it through site easily. Even soon we launched the online service for that. However, if there's any dispute, it should be through the court.
Okay.
Okay.
Yeah.
Thank you very much, Mr. Abdulrahman. Thank you, Bashir. Just for the audience, we have 3 more minutes to go through the seminar, and then we will be taking questions. So you can already prepare your questions and submit them through the chat box. Now I would like to turn to Mr. Majid, and we have 2 more minutes to speak quickly about patents, and I have 2 quick questions. Today, when we prosecute patent applications in front of SIPE, of course, we always look to expedite the process. You've spoken about the agreements conducted for the patent prosecution highway agreements with the USPTO and South Korean Patent Office. Now, absence the application of these vehicles, are there other measures to expedite the prosecution of a patent application in front of SIPE? For example, if an applicant has an equivalent patent application already allowed or accepted in some other major patent offices, like the European Patent Office, for example, would that impact provide at least, a positive leverage on the expedition of the prosecution process in front of SIPE?
As you may know, Mr. Ahmed, the granting decision is independent of any other decision made by other patent offices. Okay. However, this doesn't preclude the examiners from taking the advantage of work sharing with other offices, because the search and the examination report are useful in helping examiners to make their own decisions. But finally, the decision of grant or reject, this is being taken independently and basically it's governed by the law and the guidelines that SIPE has been set for this
okay.
procedure.
Okay, and many ask about the GCC patent of the GCC patent application. Can a GCC patent application coexist with a KSA patent application, or a KSA patent coexist with a GCC patent?
Yeah, actually, it could be, but this is not the right way to protect. The GCC Patent Office is supposed to be sure that there is no application in KSA where the prosecuting the application. But from the legal perspective, no country over the world accept two kind double patenting for the same application. Okay, but from the legal perspective, it could be exist two patents here from SAIP and from GCC.
And from SAIP's perspective, SAIP doesn't have any issues in examining and granting a KSA patent in case the same invention has been subject to a GCC patent, right?
Yeah, of course.
Okay. That my last question to you, Dr. Majid, and this is about artificial intelligence. And all the world today is turning towards artificial intelligence and developing innovation in this respect. And the KSA has recently, I think, the last year, taken a very, let's say, particular decision in granting citizenship to a robot, and many consider this step as a leading step towards the future, and it has, of course, many many meanings and many connotations and interpretation to this decision. However, it's a very many see it as a very positive step to encourage more investments in this field. We know that a very important aspect of patents is inventorship, and an inventor so far and traditionally is considered, an inventor, an individual. And so far, all countries in the world, if not most of them, at least the wide majority, require an individual to be an inventor and not a machine. And we know that there's an ethical issue about this and a philosophical issue or dimension around this. With this step, the KSA providing a citizenship to a robot, do you foresee that SAIP would be willing or at least considering going in a direction to allow machine inventors? Is it something that you foresee in the future?
Yeah, of course. Actually, SAIP now is doing major review and development for the patent examination guidelines. So, for example, the computer implemented and pharmaceutical policies can be subject for this development project. Anyway, we have working a group for this purpose to develop the guidelines and reviewing the regulations to be updated later on. This study will clarify the policy parameters for those to be dealt with. But until now, still there is nothing changed for the inventor to be human kind. So after reviewing and developing the guidelines, there could be some change in the future.
Okay. Thank you, Mr. Majid. So we have a question. Now we have 10 more. We have actually So we have 10 more minutes for questions and answers. So we have a question here about the cancellation of a generic trademark. So the question is, if a generic word was registered as a trademark, can any party apply for the cancellation of the trademark? And here I trust, what is meant by the cancellation is in front of the the judicial procedure in front of the court. So maybe there's a question of legal interest. Bashir, turning to you, what do you think about the cancellation of a generic trademark? Can any party, with or without legal interest, apply for the cancellation of a generic trademark?
Well, they must have legal interest in order to be able to apply for the cancellation of the trademark. And that legal interest is that they want to use that generic mark because it's generic. It lacks distinction, and therefore they must show their intent to use and the risk that they want to avoid the risk of facing a trademark infringement claim from the registered owner of that generic mark. Mm-hmm. So that would be the basis of their cancellation action.
And for just for the audience, clarification for the audience, can you clarify what's a legal interest? Is a competitor is considered to have a legal interest? In that?
Yeah, a legal interest is an interest that a competitor may have, that a trader may have, in this case, in using that generic mark. It must be an interest that relates to them directly, and that affects their position in the market in this context, but also a legal position in terms of the risk of facing an infringement claim from the registered owner.
Mm-hmm. Mm-hmm. Mr. Abdul Rahman, in terms of registration, during the registration procedure, I trust it's one of the things you look at, right? Whether the trademark is a generic trademark or it's a distinctive trademark, right?
Yes. Yes, of course. Usually the generic words or generic marks, this could be registered.
Yeah.
However, as you might know, in some Western countries, they use the trademark for a long period as a trademark. Then they, because they use it for
acquired distinctiveness.
Yeah. So they're eligible to register it as a trademark in their countries.
Yeah.
Then from this point, they can move to another countries and register it because they have it already registered in their country, and it's become famous. Then once they arrive to Saudi Arabia, for example, in our situation here, we should usually evaluate this trademark. Could be a mark that become a well-known trademark, so we can register it because it is a well-known, rather than it is a generic or not. However, in some cases, we reject these applications because it's purely generic. It could confuse consumers, and once these conditions could apply, then we should reject it. In some cases, they went to the court and won the case, and they registered the trademark or this generic word. But in some cases, they couldn't. So it depends on the generic, the word itself. Is it make a confusion for the consumers or not? Is it too generic so anyone can use it? In some cases, the generic word, it is combined with other designs, for example, that make it as a distinctive mark, even though it's contain a generic word. So the protection should be to the whole trademark, not to the generic word that's used in this trademark.
Saleh, we have a question about seizing counterfeit goods in the market. How effective are the administrative procedures today available to a brand owner for seizing counterfeit goods inside the market?
The seizing goods from the ACFD, we have seen recently a lot of improvement and a lot of assistance by them during the COVID-19. As we all know that COVID-19 has certain issues from international clients that needs to provide POA. So certain arrangement has been made by the ACFD in seizing and seizing the counterfeit products. The procedure basically starts from filing a complaint before the ACFD through Ministry of Commerce. There's a certain committee that needs to be studied by the ACFD in order to determine that if the product is counterfeit or not. Once they agree by the committee, it will directly transfer to the raid department in order to proceed and seize the counterfeit products. As I have mentioned, we have seen a new position, a new strategy that now they're implementing in the ACFD, which now is centralized in Riyadh. So all the complaints needs to be transferred to the Riyadh in order for the committee to make their decision and then sent it to the region that is located the counterfeit.
Thank you, Saleh. We are 3 minutes from the end of our very interesting and rich session. I would like to take advantage of the remaining 3 minutes to ask our esteemed invitees, Mr. Abdulrahman and Engineer Majid. So about your recommendations for respectively, Mr. Abdulrahman, for brand owners in terms of any practice or any recommendation you want to provide them, and for Mr. Majid, any recommendation or comment you want to provide to patent owners who are today here and listening to you.
Yeah, actually, here in Saib, we are very interesting to collaborate with the applicant and make it easier for them to reach to Saib and facilitate the communication between the examiners and the applicant. So to make it easier for them to understand if there is any objections, to overcome this objection and to speed up the prosecution and get the patent easier and faster.
Thank you, Mr. Majid. Effectively, and we testify about this. We've had many examiner interviews with your examiners, and they've been extremely helpful. And this practice really helped into expediting our clients' patent applications in front of SAIB. So thank you for this, Mr. Abdulrahman.
Thank you. First of all, thank you for everyone, and thank you for this panel. I do suggest and I do advise the applicants to register their trademarks. Even it is famous, please do register your trademark. We are always happy to protect your trademarks. once it's registered, make sure it is protected. Also, we are inside open, always we are open to hear from applicants. In fact, we call them as our clients, not just your clients. As agents and other offices, they are our clients. So we are so happy to discuss, to answer any question, to clear any confusion. We are also very happy to help and provide any advice in relation to registration or any aspects of the IP inside.
Thank you, Mr. Abdulrahman. Effectively, you've been extremely helpful to us and to our team in Saudi Arabia in advancing our clients' portfolio in Saudi Arabia. So thank you very much for this. Dear audience, thank you very much for your time. It was a real pleasure for us to provide you with this seminar. Please stay tuned with us for the future seminars we will be conducting with SAIP. Thank you, SAIP, for your time and for this beautiful partnership with Al Tamimi and Company to provide brand and patent owners in the region here and internationally with a very practical and useful insight to protect their brands and innovations inside the region. Thank you very much all and have a wonderful day.
Thank you.
Thank you very much.